Hey guys, my name is Laith Abu Talib. I'm an attorney. I work for Finnegan Henderson in DC. I'm also a UMD alum. I graduated from here in 2012, so not that long ago. I graduated from the bioengineering department, and then after there, I went on to law school at George Mason Law School. I did law school during the day, and I went to Maryland as well at night to get my master's in biomedical engineering also. And so I've been part of the Maryland community for quite a while. When I was at Maryland, I was involved in startups myself, where I had 2 startups. One of them grew to 40 employees my senior year, and then stopped. And everything went to shit after a while, but because I didn't know anything about patent law and intellectual property, and so I decided to go to law school based on that. So what our technology was, we worked on, as part of our capstone design project in the bioengineering department, on helmets, on concussion-reducing helmets. We used dilutant fluids and different kind of chemical reactions to put into a sleeve between your helmet and your shoulder pads, and so that at certain forces that tenses up, absorbing some of the force, eliminating concussions. And so it was great technology. It worked out pretty well. We had a lot of discussions with bigger companies to buy us out. We were talking to Riddell. We had a lot of high schools interested in our technology. We also had Robert Fischel himself, the namesake of the Department of Bioengineering, interested, and he ended up coming on as a co-founder. So did Professor Kiger in the mechanical engineering department, if you guys know him. And then, as I said, after a while, it just kind of stopped. And we had employees. We had our own 3D printed designs, which was crazy at that point. I was just telling Chris, we spent $2,000 getting our prototype 3D printed, and now I hear it's free. That's crazy. This was only 4 years ago. And so we spent $2,000 getting our little spring 3D printed, and then it actually broke on the drive home from the 3D printing lab towards campus. So that was a $2,000 loss. But essentially, all these things were happening, and we grew too fast, and we didn't know what to do. We had no trademarks. We had no patent laws. We had no patents, design patents, copyrights, no trade secrets, no NDAs. But then when we sat down with Robert Fischel, his attorney was there. And then we just signed all these forms because we were engineers and we didn't know what to do. And so we signed a bunch of forms, non-competition agreements, non-competition clauses. And if anybody asks you to sign that, you should get up and walk out of the room, I would say, at this point. But so I just want to tell you guys about the lessons that I learned doing that and what I know now as a patent attorney. So as I said, I work for Finnegan, and Finnegan is the biggest patent law firm in the whole world. We represent clients like Google, GE, Philips. We were actually Google's patent firm when they were still a startup. They had 2 people, Sergey, the Maryland guy, and then we were employee number 3 of Google. We were employee number 2 at Yahoo. Did the same for a bunch of other big companies, and now we still work with big and small companies left and right. So what does a patent mean? Right? So in the beginning, you start out with a flash of genius. You find a new way to solve something. You either have a 3D printed something, you have a physical prototype, or you have a website, you have an app, you have something that people need. How do you protect the innovation, and why do you protect it? So you want to protect it because you invested time and money into this idea. You should be able to recoup that investment, and that's what IP is all about. It doesn't really make sense for you to put in $100,000 into research and development or $100 in R&D and then not benefit off of that initial investment. So how do you protect your IP? When we talk about IP, we like talking about walls and blocks, hence this brick wall right here. So each brick here represents a certain kind of IP. When I say IP, by the way, I mean intellectual property. I mean design patents, I mean utility patents, I mean copyrights, trade secrets, all that stuff. Now the favorites are utility patents right here. This is what a patent looks like, and this could be a patent for anything from a gear to an actual entire car to the resistors that are in your phone, to anything. Other favorites are trademarks. That's something that a lot of people like to get. Little known players are design patents, and you guys might know about design patents because of the Apple-Samsung litigation. So anytime people talk about the Apple-Samsung patent wars, they're literally only talking about the shape of your iPhone. That's all they're talking about. Nothing else. Is just the black rectangular shape of your phone. And that's what they sued Google over and Samsung over, and that's why we still have iPhones. And that's why Nokia is no longer a player. And copyright is another player as well. And that's something that's not that important. Trade dress is pretty important. You can trade dress and essentially have exclusivity over a color, like Tiffany's. You can have exclusivity over the shape of a car or how something looks when it's operational. A few important things that everybody should know before I ask you guys what industry you're in is that you have to always keep things as secretive as possible. You don't want to tell everybody what your idea is at any time. You don't want to tell anybody, you don't want to give them the keys to your invention until you have different agreements, until you have NDA agreements, until you have exclusivity agreements, until you have a lot of different kind of stuff. And now I'm going to talk about differences between trade secrets, patents, and all that kind of stuff. But before then, just so I know where to focus on, because this is going to be very informal of a talk. Are you guys mostly in like the computer industry, in the physical manufacturing industries? Can we get a show of hands for like computers and apps and that, like softwares? What about physical building actual products? And what's the other tertiary group? You guys can yell it out. Anybody else? Services? What kind of services? Okay. Food delivery. Okay, perfect. Perfect. So all three of those will be there. If I get boring because I'm talking about one topic that nobody cares about, let me know, because then there'll be another topic that everybody cares about. So seriously, just let me know and I'll fast forward through anything. First thing is going to be patents versus trademarks, and also feel free to ask me any question at any time. First thing we're talking about is patents versus trademarks. This guy right here, Thomas Edison, he's a cool guy. And these are all different trademarks and trade dresses of different places. And I'll discuss this slide in a bit more soon, but as you can see, this is not what Crest toothpaste looks like. This is certainly a chocolate bar. So first we're going to talk about patents. Utility patents and design patents. There are two kinds of patents. The first kind is a utility patent, and that's what you would get for your actual physical thing, right? Whether you're making a part of an engine, whether you're making part of a drill, part of a phone, your electrical components, your screens, your batteries, whatever that is, you protect that with a patent. And what a patent is essentially is you writing down how you made this thing, what is impressive about it, what's unique about it, and then you file that to the United States Patent and Trademark Office, the USPTO, where half of you guys will be employed probably in a year or two. And then they look at it and they say, okay, you are the first person to do this, done. Here's a 20-year market exclusivity over your product. That means you are the only person that can sell your product in the whole world, in the country at least, or you can also designate other countries, but in the US. And so that's huge, right? You've invested all your time and money into this. It's a race to file first. All of a sudden, or on the other hand, you could be working on your invention for quite some time, and then somebody patents it before you, and then you're kind of screwed, because then you can't practice it. So that's why it's always a race to get to the patent office. That's why it's always better to patent earlier than it is to patent later. And so patents are essentially easy to understand because it's definitely just technology. The tougher parts are design patents and trade dress, which we'll talk about right now. Design patents can be anything from the shape of a chair. This is a Herman Miller chair. This chair costs $400 or $500, but these chairs don't. They look similar, but they don't look exactly the same. So this guy, Herman Miller, decided, hey, I want to make expensive chairs that do the same exact thing as every other chair in the world, but I want to make it distinct so that people will sit on it and they'll know they're sitting on a $500 chair. And so that's what he did, and now he's a billionaire. Google, we're talking about all the software people. You can also design patent the shape of your website. So Google first got this patent. They filed for it in 2006, and they got it in 2009. That was a 3-year-long process. But what do you see here that's unique? It's almost nothing, right? For like at this point, we're so used to seeing this. But what they did was the homepage that you have. And so this simplicity, Google said, you know what? We're going to invest in our simplicity, in our minimalism, and we were going to have only the words and a search and go, and I'm feeling lucky. That's it. And they did that, and they made a lot of money because they were the simplest thing out there. Amazon.com's homepage with the card on the upper right versus somewhere else, that's a design patent. And to stay on the subject of internet technologies, Amazon.com also has a patent for one-click technology, which they licensed from eBay when it first came out back in the day. What does that do? That saves 0.008 milliseconds per purchase on the back end. And when you multiply that by a couple million, all of a sudden, this is a very valuable piece of technology. And so you can patent the way an algorithm. You can patent how it worked, how they made something faster, how they made something better, and then they recoup that investment. And now we still know about eBay and Amazon, but we don't really know about any of the other companies. So again, to go back to design patent. A design patent is just the ornamental shape of your thing. Whether it's a chair, whether it's a drill, whether it's these little lines, the marks, that kind of stuff. And nobody else can have that design. But this is just ornamental. So this is talking about your website design, your product feature, if your service has a certain kind of thing that you're holding onto it, or online or not online. You can also color that and make it trade dress. Because when you look at black and yellow, you think Black & Decker or Caterpillar. When you look at the blue of Tiffany's, you think Tiffany's. When you look at red and yellow when it comes to a burger joint, you may think Wendy's, but you're probably thinking McDonald's. And so you can trade dress something and have eternal, perpetual rights. A good example of that is a Coke bottle. So in 1937, this dude got a design patent on the shape of a Coke bottle, of a bottle. Bottles have been used for centuries at this point, but this guy said, you know what, I'm going to make this a little bit thinner from this side and a little bit thinner from that side. Let's see what happens. And who knew? He knew, but nobody else knew that that would all of a sudden be the logo of Coca-Cola forever. We know Coca-Cola because they've had ad campaigns with that curvy logo. They've had marketing campaigns. They've had everything with the shape of their logo, the contoured bottle design and registered trademarks. And Pepsi can't do that. So is that why Coke is a bigger company than Pepsi? Maybe, maybe not. But it certainly helped them get there. Right? It helped them get a little bit more unique. So always think in the terms of what do you have that is unique? And if it's nothing, then find something that makes it unique. And then make it so that it's always unique. So that you're the only person that can do that. And that's how you build a brand. Right? Angry Birds started in 2009 as an app, a gaming app, and now they have a movie, a feature film, a movie. Because they design patented the shapes of these little guys. They have a trademark on the logo Angry Birds, and it hasn't changed since the first app. And they've design patented each one of these figures. And now they're on backpacks and shirts and clothes. But we know a lot of games that started at that time that didn't grow this far. So you always have to think about why. Why did they not go that far? Why did Angry Birds succeed so much, and why did other companies not? Why did my startup fail and other startups succeed? You know, I think it's because of this. I think it's because you have a forward-thinking. They did the same thing. Louboutin and Yves Saint Laurent. Louboutin got a patent or a trademark on the color of their heels. These guys didn't, and so these guys sued these guys for over $1 billion because of the bottom of a shoe being a certain color, which is ridiculous, but it's a way to build businesses. So now we're going to go into trademarks, which involves everybody here. There are 3 different kinds of trademarks, and you have to think about this before you have your business, right? So when you have your business, you have to have a name that nobody else has, because that's going to be your trademark. Angry Birds, Apple, Google, whatever that is. You want to make sure that it's distinguishable from other products, and you want to make sure that it's not an industry term like table or something like that. So there are 3 different strengths of trademarks. The strongest trademark is a coined term like Google. Google means G-O-O-G-O-L is like 1 with 100 zeros or 500 zeros, something like that. But it means nothing essentially. Yahoo is a coined term. All these other places are coined terms. The next strongest is a suggestive mark, and the third strongest, the weakest, is a descriptive mark. And I'll give you guys examples of that. So Google, Exxon, Coca-Cola, Nike, you want to have a name like that. Sorry, go ahead.
What about standard character marks? Isn't that just like, that's what I've been seeing on the USPTO website. Isn't that just like own name?
Yes. Yeah. So to go back to here, for example, Angry Birds has a trademark on the word Angry Birds and on the colorized logo. So that's 2 separate registrations. One is, like you're saying, just standard characters, A-N-G-R-Y space birds. So it's just that. And the other part is what it looks like, right? And a good example is Angry Birds, but a better one is Coca-Cola and Coke. So you can't say Coca-Cola, and you also can't use that kind of font to say something else, because that's their font. So there are 2 separate forks that you have to take both sides on that side. Does that answer your question? Yeah. Anytime. And so you have Google, Exxon, Coca-Cola, Nike. Those are all different words, and nobody knows what they mean. And Nike is a much more powerful term, trademark, than Under Armour is. Finnegan, we represent Under Armour in the trademarks department, and they sue people every day for using the word body armor, like the drink, or whatever else armor. Right now we're in a big lawsuit against somebody called Ass Armor. And it's a legitimate company with legitimate law firm, and they're huge, and they sell briefs with ass armor, literally. But Under Armour has spent so much money fighting these guys in court to make sure that they're not diluting their brand. And so if they went back 15 years, maybe they wouldn't have chosen Under Armour. Maybe they would have chosen something else, like Nike or Adidas or Reebok. Apple is a good example. Camel cigarettes is a good example. Apple means something, but it means nothing in that industry. Camel cigarettes mean something, but it means nothing in that industry. And that's okay. That's also strong. What is less strong are things like copper tone, even though that sounds like it's fanciful, but it's not, because copper, color, tone, something, sunscreen, oil, this, that, so it makes you think of a color. Chicken of the Sea is also weakish, but also still strong. The weakest are things like Sports Illustrated, because that's literally what it is. It's a sports magazine. Raisin Bran. That literally is what it is. Best Buy. It's not that strong. Home Depot. It's not that strong, right? So that's Bed Bath & Beyond. I guess Beyond makes it a little bit confusing, but you know what I mean. So that's something that you guys should all think about when it comes to trademarks. And searching before you do anything. So if you want to name your company Under Armour, I hope you Googled right before that other companies that are maybe called Under Armour, or that are similar to the name Under Armour. So having that kind of introduction is always good. And also know that you don't always have to file for a trademark right away. You have to actually show use in the States. So when we're talking about a Q food truck, for example, whatever else, you using it is necessary before applying for a trademark. And until you do that, then you're not protected. Then somebody else can say, oh, that's a good name for a business. I want to do that too. And that's what they do. Now, we're going to talk about trade secrets a bit too, and that's important to all the software guys also. Examples of trade secrets. So what a trade secret is, first of all, it's literally what it is. It's just a secret. It's a trade secret. Like the recipe for Coca-Cola, or the algorithm or Google search engine algorithm. Nobody knows how it's done. The Coca-Cola recipe is known by one person, and then everybody else that does everything about it knows only steps A and B, C and D, E and F. So nobody really has the full picture of how Coke is made, of how the KFC recipe is made, of any of those things. It's a trade secret, and that's legally protectable. And this is a great thing for the software people to do, because the second that you patent your software, the algorithms, it's disclosed, and everybody knows it. And then you're going to find some random smart person in some school, and they'll do it faster, and they'll do it better. So keeping that secret is always a better thing, or could be a better thing, depending on your individual thing. Like, for example, the New York Times bestseller list is actually a trade secret. It has nothing to do with who sells the most books, believe it or not. It's not based on any kind of market things. It's weird, it's strange. But you can look it up, and nobody will tell you how, and they won't tell you how they come up with their list. It's based on marketing and selling and this and that, but it's based on a bunch of different stuff, putting into their algorithm in a certain way, and then all of a sudden you have a bestseller list. And that's how that works out. And that's why you have a lot of people saying, like, New York Times bestseller, but it's like, who has read this person's book? Oprah probably did, but that's it. The Facebook trending, Twitter trending, that's also a trade secret. Facebook trending is still pretty shitty, as you guys know, but Twitter trending is still much better. But it would be way easier for Facebook to catch up to Twitter on the trending part if Twitter patented their stuff, but they didn't. They kept it as a trade secret. And so now Instagram is trying to do the trending, but it's still not going to be necessarily as good, perhaps, as the first movers, which was Twitter in that sense. Coke recipe, KFC, Google search algorithm. PageRank was a company that Google bought. PageRank did search engine optimization and finding before Google was awesome. And then Google was like, hey, look, this company sounds cool. We're going to buy them. And they did, and then they became part of Google. And so that's why also for the little people, it's so important to keep yourself as a trade secret, because you never know who's going to come knocking, whether it's Google or Under Armour or whoever else. You can also mix patents and trade secrets, like Cadbury and a lot of different kind of chocolates. This is a long, boring slide. I didn't make it, I'm sorry. But essentially, you can claim stuff and be as, this is what a claim looks like in a patent. And everybody here is a smart person, and nobody's going to understand what the hell this means. Neither do I. a method of manufacturing chocolate comprising the steps of feeding cocoa liquor and, optionally, milk solids to form a film thereof on a heat exchange surface of a heat exchanger operating at a temperature of 35, like under a sub-atmospheric temperature. It doesn't mean anything, right? But this is what a patent is. This is what I do for a living, unfortunately. But this is what I do, right? It's like when people come to you with inventions, with their ideas, and what I do is I sit there and I put it into English or whatever language you would consider this is. But you put it into that language, and that's how you file for a patent. And that's how that is. So as weird as this is written, this is still a Cadbury patent. So you're talking about this is probably done by one of the most powerful law firms in the whole world as well, right? So they know what they're doing, and this is what they came up with. Like all the smart people in the world came up with this weird thing. But one of the reasons why it's vague is so that they can keep some stuff as a trade secret, because nobody knows, like operating at a temperature of 35 to 145. That could be 144, or it could be 35, it could be a lot of different things. So you keep things a little bit secret to make sure that even though you file for a patent, nobody else can do it. Now let's talk about trade dress a little bit too. This slide comes back from the first slide. Trade dress is very important, and you should always think about it from the beginning as well. Right now, we all know that yellow sugar is Splenda. A yellow sugar packet cannot be anything else but Splenda. How did that happen? It's because they always used yellow from the beginning until the end, and then they grew in sufficient size in the market, and then that's it. It becomes theirs. And if the public associates you with that, then that becomes yours. Like the term escalator, for example, used to be a company called Escalator. But now everybody calls it escalator, and it goes into the public domain. And then nobody else can now use the word escalator to design their moving stairs. Google spends millions of dollars every single year to make sure that it capitalizes the word Google every time you say it, instead of saying like, yeah, I'm going to Google that. It's like, no, I'm going to go on Google and search for that. And that's why it's always tough with Apple. Every new update, type in Google and it won't capitalize it because that's their biggest rival, right? Apple wants to make it a generic term, but it's not going to happen as long as Google is a zillion-dollar company. But so you can acquire perpetual rights by maintaining your color, maintaining your brand, and then it becomes yours, like the black and yellow, Black & Decker. This, for example, we all know is Coca-Cola. This is Camel cigarettes. This is Reese's. This is Kodak, Hershey's. Even though it's not saying Hershey's, and this goes back to your question back there, was you're not just trademarking the actual word, the black and white word, you're also trademarking the logo, the look, this, that, and then you use it for long enough, and all of a sudden it's yours forever. And that's always a good thing. Red Bull. Is Red Bull much more delicious than Monster? Maybe, maybe not, but it looks different, right? It's a smaller can, it's interesting. Is it easier to drink? Is it easier to hold? Who knows? But it always spills in my cup holder, and it's always annoying, but I always will buy Red Bull. I don't know why, right? And so this, again, makes you want to think about how do I become a little bit more unique? And that's how you can become a little bit more unique. And now they have Red Bull channels and Red Bull racing teams. F1 racing team, it's called Red Bull Racing. And so you have them grow into something so huge, and it's not because of their taste. Like, I think objectively we can say it's not the most delicious drink in the world. But we still drink it, maybe because of the can. I think it's because of the can. Apple, I guess I gave it away, but we all know what the store is, right? And that's because it's Apple. You can trade dress the shape and design of your store, even. And now, 10 years later, you have the Microsoft store that looks a little bit different. It doesn't look the same, so what Steve Jobs wanted is you walk in and everything is in this direction and leads you to the next thing and all that other weird stuff that Microsoft now can't do, but Apple can. So that's cool. And now we're going to go into, this should light up copyrights and not trademarks. Copyrights, I was going to leave until the end because it's not the most important thing in the world. It's really important when you have creative expression. So you're talking about a song, you're talking about a design like this that does nothing except for be a design. Nothing else. It's only design. Manuals, you can copyright manuals. And the benefit of copyrights is that you can stop things at the border. Instead of suing people eventually year-long processes, you can stop things at the border. So you're talking about your apps, even perhaps your manuals, your instruction books, all that kind of stuff. So the final question is, which is best? Do you want patents? Do you want design patents? What do you want? And the answer is as many as you can get, right? As many as you can get, and everybody has an individual answer for that. But what I want to do for you guys is to make you think about this, because I wasn't thinking about this, and I should have. And I'm telling you right now, as from experience, I'm not a million years older than you guys, but if I was you, this is what I'll be thinking about all day. And we put all our money into R&D, we put all our money into marketing sometimes, we put all our money into surveys and driving to different companies to do the surveys for us. What we could have done and should have done perhaps is put a little bit of that budget into IP. Or having one person on our team Google what the hell IP means. And how do we file for a patent ourselves? How do we file for a trademark ourselves? What is a patent? What is a trademark? What is an NDA? And figure out that kind of stuff. So the answer is everything. If you have an actual article, like a physical product, you might want to design patents and the utility patents, probably together. If you have something that you're selling, trade dress. If you have a logo that you want to have expand, you're thinking about trade dress, like Reese's, like Coca-Cola, like Google. If you're thinking about anything, actually, trademark should be for everybody. Copyright, forget about that unless you actually need it, and we can talk about that, but you probably don't. And then trade secret, everybody should always make sure you keep yourself secret as well before you think about any kind of protection. One of the benefits of IP that I wish I knew at that time was that if I did file for something, I wouldn't be worried about hiring 100 people under me. It will be okay because they're not going to steal it because I already have protection. It's fine. So that's something. You have to know some stuff about this and international stuff. And that's that slide, and that's me. But before I finish, one other thing that I wish I knew also was this thing called Provisional Pad, which essentially is the beginning of a utility patent. As I described earlier, it's a race to file. It's a race to get the patent office and say, hey, I made this remote. But before then, for $100, and yourself you can do this, is you can file whatever you want, whatever kind of handwriting drawings you have, presentations you've given to whatever. If you file that at the patent office and call it a provisional, you have to put a cover sheet on it, and you file any kind of presentation you have. It's never going to be looked at. It's never going to be examined. It's never going to be public, ever. But it expires after 1 year. It gives you 1 year to say that I was here first. Nobody else can patent what I just made for that year. So you have that 1 year to secure funding to have an actual utility patent, because that costs more money. You have that year to secure your idea, to do this, to do that. So we have a lot of companies that file provisional patents literally every Friday. There's one company that I'm working for, GE actually, they file a provisional patent every single Friday on something that they may patent and may not patent. But it's for $100. And they're like, here, just do it. We have a whole year to decide from this date whether we're going to move forward or not. And so provisional patents are something that I'd also strongly recommend a quick Google search of. And that's me. My name is Laith, and this is my contact information if you guys want it. And any questions? Yeah.
I was wondering, you know when like you check out a patent, like something that's already been filed and claimed and like they've gone through the whole process, and then you see that there's like 13 different cited patents. That's something that the USPTO decided on that person found, right?
Yes and no.
Yeah. So what exactly does that mean?
So let me tell you what that means. So let's say your technology is a new kind of computer, right? And you want to file a patent on that. Before you file a patent, you have to show the patent office that you made a reasonable search for other things like this. And so you're going to list 10, 15, 20 patents, the closest, they call them prior art. The closest prior art that you can find, you're going to list those in your invention disclosure statement. You're going to send it to them. They're going to look at those 20, they'll be like, yeah, 3 of these are cool, 5 of them aren't, we're going to worry about these 3. And then they're going to also search their databases, aka Google Patents, for a whole bunch of other patents, and then list those as well. So you'll see a lot of times the cited patents are in the hundreds on certain applications. So that's something that both you do and they do. Yeah, keep going.
You said like you have to do like your own search.
Yeah.
But I keep getting told that like you can't do your own search. You have to hire a search firm.
A search firm will tell you that. But a former person in your shoes strapping for cash, you can definitely do it yourself. 100%. Yes. What's hard is reading the patent. Literally, to go back to this weird thing, it's like if you're going to make a new chocolate bar, there's no way you're going to know to put in the search terms on the Google search, said material with sugar having a particle size distribution such that 98, you're not going to write that down, right? And so what takes me or the search firm 20 minutes will take you hours or more than hours, maybe days, but you'll still save a bunch of money, right? And so that's the big difference. But you can definitely do it on your own in the beginning as well, until you get serious. This is good. Doing it on your own is also good to eliminate big hurdles. Because if there's a showstopper out there, if you want to invent something that literally is out there, you'll probably find it with your own Google patent searchings. So then you'll be good. But somebody like me or a search firm will get into the minutia and into the details of, yeah, this is your actual topic, this is what you do, this is what you have, and then move forward. And every patent agent at a search firm or a patent attorney has to be an engineer also, by the way. So before I get to have a patent bar, I have to show that I'm an engineer or a scientist. So that's why the people that you're talking to will sit down with you as electrical engineers or as whoever else and look at your invention from the actual engineering standpoint. And then from there, translate that into law kind of thing. And so that's how that generally works. But yeah, you can definitely save money and do it on your own, at least in the beginning. Yeah. So the next step is to sue him, right? So the next step is to file for an actual patent because you can't sue over a provisional. But he can't get a patent on it. So you still have 1 year to figure this stuff out, to get more funding, to get more whatever. And then at that point, a lot of companies that do infringe people's stuff, like people say sue him, but that suing process takes literally 3-4 days. Because you say, hey, I have a patent on this. And then you're like, oh, my bad. Click. And that's it. Then they'll stop using it. Or if they want to say like, no, I have it, blah, blah, then it goes to a lawsuit. But it most likely won't get to that far. And most likely you just notify the person saying like, hey, listen, I have a design patent on the way this looks like. It's right here. It's pending for a couple of years, but I'm telling you in a couple of years I'm going to sue you, so you might as well stop now. And then, yeah, you can file for another provisional tomorrow. If you file for one today, you can file for another one tomorrow. And they don't have to be related. So a lot of times patents do have to be related. Your utility patents, you have to say like the parent is this patent so you can get a previous filing date and all this complex stuff. But provisionals, they're completely separate entities every single time. So you file one today and file one tomorrow. And they don't have to know about each other. They don't have to be connected in any way. It's just they're both different applications. Yeah. Yeah. No, you can't. You can't. Then it wouldn't be valid. You can be challenged. Yeah, they file that patent. Because
If I don't do anything that first year, I'm kind of screwed.
yeah, so you have a 1 year goal essentially to get your stuff done. But nobody sees your provisional though until it gets challenged, right? And so if it goes away, so you shouldn't fear you filing a provisional and then, oh shit, people know about it now. They're going to do the same exact thing because nobody's going to see it. The patent office doesn't even see it. It literally goes into a separate inbox, and then once you file for a real utility patent, you'll say with the priority number of, and you list your provisional patent, and that's when it gets seen. But if you don't do this, it'll get deleted 1 year afterwards. So you have no risk of anybody seeing it except if you want them to be seeing it. In other words. Yeah.
I was wondering, like the more cited patents on like you said like it could be hundreds, right?
Mm-hmm.
So is it like the more cited patents, the less defensible the invention? You say?
No, I wouldn't say that there's any connection between the cited patents and anything else. I think that's just luck of the draw, luck of the examiner. It has nothing to do with anything else. I wouldn't think of that as anything meaningful, in other words. Yeah. Yeah.
I feel like a big issue with a lot of us here with patents is we don't have the money to
Mm-hmm.
sue someone who infringes on the patent.
Mm-hmm.
Does it make sense to not wait to file that first provisional patent as long as possible? So, like, only after we see someone else is doing something similar, then we file our patent?
So a patent, so one of the reasons why people get patents is to make sure you're the only person using it, right? To be able to sue people and say, hey, stop that, this is my technology, get out of here. Another reason is to get money, right? And so if I had a provisional patent on my helmet technology when I was here, I would have been able to sit down with Robert Fischel and say, hey, look, I'm protected. Instead of buying in for 20 bucks, which is what he did, I would say buy in for $20,000. And I'll say, okay. And then I wouldn't be here right now, right? But so you have a big difference in stature at your stage, which is fundraising, right? All you're doing is trying to get more money. And so if you say my stuff is patent pending, it's much more valuable than you can imagine. So you get money because it says patent pending. Somebody does something else, you sue them with your newfound investors, with your newfound money, all that kind of stuff. So it's all tied into one thing, right? And if he's going to do it anyway, if this person's going to infringe on your stuff anyway, he's not more or less likely to infringe on it if you have a patent or not. But if you have a patent, you're then protected, right? So that's your screen. You thought of it first, no matter what, whether that's on a provisional or not on a provisional. You thought of it first. And so he's going to do it anyway or not, in other words. One way, you'll have more money in the fundraising field and that kind of stuff, and you can sit down with VC firms and talk about things. Another way, you just simply can't. So that's the big difference between the two. It depends on so many things. If somebody comes up to me right now with a patent on a sleep apnea machine, and I just wrote one 2 days ago, it's going to cost maybe $2,000 to $4,000. If it's a brand new technology that's as simple as perhaps a pencil, that is intricate in its own way and has no prior art, no set of documents that I can look for, it might cost towards $7,000. But it's always negotiable when it comes to that individual firm, different firms, and that kind of stuff. People will always work with you to get that stuff happening. But beware of shitty patent firms. And I'm telling you that right now because I used to work for one. And a lot of them are just really unethical places. They'll say, oh yeah, we'll follow you 20 patents on this. And you'll get it in 2 years guaranteed. Well, that's bullshit because if you get it right away, it's like going to buy a car. And you say, yeah, I'm going to $1,000, that's my offer on this car. And the salesman says, okay. That means you literally lost money, right? You want it to be negotiation. You don't want somebody to tell you, I will get you a patent duration of time. Because if he does, then he's not negotiating, he's not taking your money and he's running with it. And also the big difference working with a non-respectable firm is a firm that doesn't need your money won't lie to you. And so a lot of people come up to me saying, hey, this is my technology, you do, and I would say, that's fine. Keep it as a trade secret. Write a contract. Don't tell a lot of people about this. Hire this guy to do this part, and that's it. Okay, thanks, bye. And that's done. But if I was at my other firm, he would say, okay, $5,000. That's like, well, you're not going to make money off this patent. You're not going to do anything. And so that's always, I mean, you should think. You should go to multiple places, but you should also just assess whether you need a patent or not, and that's what a good patent attorney would help you do. Do you need this or do you not need this? Because sometimes you don't need it. Sometimes you do. In my specific part, I needed it when I was doing my startup. It would have been ridiculously helpful, but nobody told me to get one. But if I was doing something else, perhaps, it wouldn't have been helpful. You know what I'm saying? So it always depends on the individual person, I would say. And I'm always here to answer questions, like personal questions like that. Like you can literally email me about Finnegan or about any other firm and say, hey man, look, this one search firm is charging me $4,000 to search for this. We're like, no man, don't do that. Or I'll say that's fine. That's a good price. So you always have me at the network. You always have, I'm sure you have a random lawyer somewhere. One of these professors will be able to help you out. So utilize your network and know the difference when people want to help versus when people just want your money. Because there's always going to be a difference, and I think you'll be able to tell. So find the people that want to help and then ask them those questions, I think, to answer your question in 20 minutes. Yeah?
You were talking earlier about like employee agreements, like non-compete, non-moonlighting, non-disclosure.
Yeah.
Do you know anything about like negotiating with companies? Like I signed it says hold my intellectual property as I'm employed by Patel, is owned by Patel.
Okay.
Like, do you know anything about like negotiating with your current employer, trying to like get that clause a little bit lessened?
You already signed it?
Yeah, I already signed it.
Yeah, so I think that it's a very, like we can talk afterwards, but that'll be a very specific thing that you have to negotiate in and out.
I'm working there. I signed it like at the beginning of the summer. I'm still working for them. And what are you doing to work on company time? Or no, they said like, it doesn't even matter if it's company time. No, it does.
So it depends.
All intellectual property, literally, if I was in the shower, people would be belongs to them.
So according to the contract, that's right. But say that in front of a judge, and like you're saying, the judge is going to laugh at you, be like, well, it's not company time. And it's not company technology. So for example, if you're working right now on, what are you working on? Are you working on like hardware stuff? What are you working on?
Hardware.
Okay, so if you're working on that specific hardware, and then all of a sudden you have an idea in the shower, but it relates to this, then they might have a case, right? They might say, well, maybe you thought of this because we invested our time and money into you, right? So if you put yourself in their position, if you hire an employee and you teach him the ropes about how to make water bottles, and all of a sudden he has an idea for a Coke bottle, they're like, what? I literally taught you everything you know, and I hired you for this. You can't go and take my intellectual property and do it somewhere else, kind of thing. So it'll always be a very specific kind of argument and question. Unfortunately, these big companies like Patel will have a lot of leverage when it comes to you signing it. Because like, what would have happened if you didn't sign it? You know, you obviously had to sign it to work there, right? So that's a problem.
Yeah. I can show you the process. I have my laptop.
We can do it afterwards if you like, yeah. A lot of companies, like when you go to VC firms, if you guys do go to VC firms, and you offer them, you say, hey guys, sign this non-competition clause, non-disclosure agreement, a lot of them will say no for that reason. Because right now you have no stature. If I went to Fischel and I was like, hey, sign this non-disclosure agreement, he would have laughed at me. He said, okay, go find somebody else. But he's right to do that. Because I have no stature, and because he's a public figure, or a public company, or he makes a living off of being a venture capitalist, then he has so much more to lose than through the court system, right? He has invested in his reputation. So if I go on whatever VC subreddits or VC tweets or VC whatever, and I say, this guy sucks, he will steal your idea, he'll steal your money, then he's never going to get another customer again, right? And so you also have the power of the law, but also the power of the market. So get as many people as possible to always sign non-disclosure agreements, but if they refuse to, think twice before you just walk out the door. If they refuse to and they're nobody, you can find somebody else, then definitely walk out the door. But if there's somebody that has invested in their reputation, then I would say it's fine to carry on and move with them. Do you have questions, sir? Thanks, guys. Thanks, guys. And again, feel free to always just email me, call me, whatever. I'm always around. And I'll answer any question you guys possibly have. Thanks for having me here, guys. Appreciate it.